So why fundamental rights are were needed? So we were having experience, colonial experience. British Raj curbed freedoms. Rowlatt Act. 1 minute. Sorry, I got some disturbances. Some continuous disturbance was there. I'm very sorry. So colonial experience because Rowlatt Act
Sir, can you repeat
1919.
first one, sir?
I am repeating first one only.
Sir.
Rowlatt Act 1919, censorship, preventive detention were part of that Rowlatt Act. Okay, so they could arrest anyone. There was no freedom of press. Censorship was there. No legal safeguard for Indians. Okay, there were no safeguards for Indians in pre-colonial period. Okay, then freedom movement demands were also there. As I told, Nehru Report 1928 borrowed from American Constitution. Then Karachi Resolution detailed fundamental rights as part of Swaraj Committee guidance. Then there was separate committee recommended justiciable rights. In Constitution Assembly, a committee on fundamental rights, Sardar Patel and K.M. Munshi were heading that advisory committee on fundamental rights. Drafting guidance by B.N. Rao was basically these people were involved in framing of these fundamental rights. So based on this fundamental right, that the need was felt and fundamentals were included in our constitution. Okay. So again, I'm continuing the same thing. International influence from American Bill of Rights, Irish Constitution, Universal Declaration of Human Rights. Human rights are also, as I told, 1948 human rights also, they want to protect human rights of Indian citizens. So for that purpose, they required something should be there to protect in constitution in writing. So they have included those things. Protect liberty and dignity, limit arbitrary state power, ensure equality and democracy. So for these purposes, they felt there is a need for fundamental rights in writing in Indian constitution. So fundamental rights are part 3 of our constitution from article 12 to article 35. Okay. It is very important. See, this article 12 is very important. I'll read. If you are having Bear Act, you can open Bear Act and see article 12 along with me. Or else I'll do one thing. I'll, for Bear Act purpose, just for temporary, I'll shift to Constitution. Okay, I'll just go through that and I'll open that.
Sir?
1 minute, 1 minute. I'm sharing Constitution. Yeah. So in Constitution, say Article 12 definition. In this part, unless the context otherwise requires, the state includes the government and Parliament of India and the government and the legislature of each state and all local or other authorities within the territory of India are under control of the government of India. So they will ask the definition of the state. Okay, so Article 12 speaks about definition of the states. Okay, just remember, there is another separate article where state is mentioned earlier also. Okay, that state and the state in any other part of the constitution is different. Only you have to take state in Article 12. Okay, India, the Bharat shall come union of states, the states are the territories, all those things. Okay, this is different from Article 12 state. Article 12 state you had to take only for the purposes of fundamental rights and directive principles of state policies. Only these two purposes, this definition applies. This definition doesn't apply for any other purpose. Okay. Article 12, and that is the reason they have specifically mentioned under fundamental rights, this definition. They haven't given, they would have given this definition before also. So the definition given in fundamental rights about the state applies only to fundamental rights and to certain extent directive principles of state policy. But it will not apply to everything. State means state, you got it?
The state includes the government and parliament of India.
I request everyone to mute. Okay. So the definition of the state is only for the fundamental rights. Here, government includes state government, legislature, and executive, state and union, and all local authorities, that is municipalities, panchayats, within the territory of India and under the control of government of India. So here, I'll explain in the slide again. I'll go to the slide. So just I want to show the definition here. This definition is only for fundamental rights. Okay, because this definition is specifically given under fundamental, otherwise they will give that all definitions under Article 2 or Section 2 in most of the acts. So here they have given it separately. We have to take it only for this purpose. So government and parliament, here another important thing in the definition, authorities under control of government of India. I'll talk about that in following thing. So executive is there, legislature is there in the part of the government, but judiciary is not there. Judiciary is not included in the government. Okay, central government is there, legislature and executive, state government, legislature, executive, local bodies, that is municipality, panchayats are there, and authorities under control of government of India. Why I am emphasizing more on Article 12 is you will get question here, even though it is only 3 lines in the article. Most of the time they ask questions from this article, concept based questions they will ask, or they will ask straight away from the section. Okay. What are authorities under control of government of India? So there is a specific ruling given in R.D. Shetty versus Airport Authority of India, because there were a lot of confusion. There were 2-3 case laws before finalizing this R.D. Shetty. So first case laws were there where it was different, but over the period, final they have given in R.D. Shetty versus Airport of Authority of India. What are all the authorities under control of government India, who are called authorities under control of government of India? So authorities who receive funds from the government, anyone who is receiving funds from the government are called state for the this specific protection from the fundamental rights. Okay, then any authority under government control, majority control also. Let us take any bank is there. In the bank, there are 10 directors are there, 7 are from the government. Then we can take it as an authority under control of government of India. Okay, functions of public importance, even though it is not under government, I mean, it is not receiving funds from the government, it is not under government control, but it is functioning, its functioning is of public importance. Okay, then it is treated as a state for this purpose. Okay, public importance, like let us take India, of course, railways are under government control. If let us assume that railways was not under government control, if it is of private, but it is of public importance. Okay, it is of monopoly status. Point number 5 is also there. Let us take Airport Authority of India. Airports are controlled some airports are controlled by private individuals, but they are of public importance. So those are also called as states. Okay, linked to any government department. If anything is linked to government department, then it is also considered under state. Okay, so like linked to government, our statutory bodies are also constitutional. Simple thing, you can take it as constitutional bodies, statutory bodies, anything formed under statute, anything formed under law. Let us take LIC, Life Insurance Corporation is there. There is separate act. Life Insurance Corporation Act is there. So if there is any organization formed by passing any act in the parliament, it is also part of the state. Okay, it is a statutory body. Even if majority control is there, even if it is monopoly, even if it is linked to some government department like Atomic Energy Department. So Atomic Energy Department is, Atomic Energy, CSIR. It is, CSIR is connected to maybe some ministry. Okay. Similarly, I am unable to collect Atomic Research Center, DRDL, DRDO. These are all connected to Defense Ministry. So they are all under part of the states for this purpose only. Please try to understand. So you cannot state that it is like government state, like you take under other sections or other articles. Only for protection of fundamental rights, we are treating them as state. Why we are treating them as state? I'll come to that. Okay. Why state is important? Because it is the duty of the state to protect the fundamental rights of every citizen. So all these authorities are state, so it is their responsibility to protect fundamental rights of citizens, and they cannot do anything in violation of the fundamental rights of the citizens. These authorities who are defined as state, any law, any act or anything, any act they do, it should not violate fundamental rights of citizen. So that is the purpose. It is clearly mentioned why state is separately defined here. So judiciary is not included under this definition. So the main reason is judiciary is independent, and if it is included as state for the purpose, so my judgment can be questioned if it is related to fundamental rights. If a judiciary passes any judgment, and they can start questioning even the judiciary, the judgments are also questioned if judiciary is included in the state. So that is the reason judiciary is not included in the state. We are talking about government, but in the government we are taking only executive and legislature. We are not taking judiciary. Only reason, because judiciary independence should be there and the judgment should not be questioned. That is the only reason Constitution specifically sees to that judiciary is not included in that state. Here another exception is there. When judiciary acts in its administrative capacity, appointments, transfers, service rules, it can be treated as state. Okay, so if judiciary is giving judgments, deciding disputes, it is not included in state. But same time, when judiciary is acting in administrative capacity, like there are appointments in the courts, transfers, service rules, removing some staff, suspensions, all those things, because it is administrative role. So administrative is related to fundamental rights. So if your fundamental rights are affected because of the administrative part of the judiciary, then judiciary will be treated as state, and you can go to court to protect your rights because of the actions of any judiciary administrative act. Your fundamental rights are affected, you can go to the court. Clear?
You are clear, sir.
Yeah. So Article 12 is talking about state. Okay. What is state? Why state is important? Okay. So because the state is, the duty of the state is to protect the fundamental rights. Fundamental rights are there for every citizen, and it is state which will implement it, which will protect that fundamental rights. So you should know who are the, and they should not violate anything in the fundamental rights. So which are states under this definition? It is clearly mentioned under Article 12. Article 13 speaks about judicial review. This is another important question. You can expect questions from Article 12, Article 13, or you can expect from both also. Okay, this is the basic principle. It is the strongest of a bedrock of constitutional supremacy in the India. Anything, any act passed should go through this lens of Article 13. Any act passed by Parliament or state assemblies or any enactment passed should go through the lens of Article 13 because it is the bedrock of constitutional supremacy. Constitution is supreme over every act. That is, judicial review process is mentioned here. Okay. In UK, Parliament is supreme. It will override Constitution also in UK. But in India, Constitution is supreme. Here, there are two things. We will talk about those things in the next slides. Okay. Pre-constitution laws inconsistent with fundamental rights are automatically void. One minute. Post-constitution laws subject to judicial review by high courts and Supreme Court. Supreme Court and High Court are having powers to review every act. So High Courts under Article 226 and Supreme Court under Article 32, they will review the acts passed by the Parliament and the assemblies. And if they are not inconsistent with the Constitution, they will reject it. Okay. So pre-constitution laws are also there because earlier, see, pre-constitution laws are like Contract Act is there. So when was Contract Act enacted? In 1872. So EPC 1908. So any law which is inconsistent or any specific article in that law which is inconsistent with the Constitution. Constitution came into existence in 1950. So anything which is inconsistent with that 1950 Act, then that part will not be valid after Constitution came into existence. Okay. After Constitution, any act which is passed in contravention or in not in consistency with the Constitution of India, then also it is not valid. So such acts are void ab initio itself, totally void if they are violating any rights of the Constitution. Okay. Judicial review is the mechanism to check the misuse of power by legislature or executive because they have power to make laws. They have power to enact. So misuse should not be done where the rights of individual citizens are affected. So these are rights are protected. So these rights should be protected at any cost. So judiciary is given power to review every act. If it is affecting the fundamental rights of citizen of India, then they will stop that act to become a law. Okay. So it is inspired by Supreme Court judgment. Okay, in 1803, Marbury versus Madison. This judicial review concept is taken from this specific case from United States Supreme Court judgment. So extended by Supreme Court in India, Indira Gandhi versus Raj Narayan and Minerva Mills versus Union of India. These two cases are very important where courts have struck down the constitutional amendment that violate the basic structure. Okay, wherever the basic structure is impacted because of any constitutional amendment, that specific section or the specific act itself is struck down by the courts. Protects democracy by ensuring rule of law and preventing authoritarianism. So even if government is having 545 seats in the parliament, all seats are won by them. The independent judiciary or judicial review will protect the rule of law. It will give supremacy to the Constitution, and it will see to that act which violates the Constitution are not becoming laws. Okay. Which laws inconsistent with the fundamental rights? Declare any law inconsistent with or in derogation of fundamental rights are void. Law includes ordinances. What are those included? Ordinances, orders, bylaws, rules, regulations, notifications, customs, usages having force of law. All these things, anything are law, and these things are which are inconsistent with the fundamental rights, they are void. Covers this particular judicial review will cover both pre-constitutional and post-constitutional law also. Before 1950, whatever law is there, which is inconsistent, or post-constitution, which is not in lines with the constitution, they can review those things. Okay. Courts are empowered to strike down unconstitutional laws. So power of courts to review validity of legislative action, executive actions. So this ensures supremacy of the constitution, protects fundamental rights, part of basic structure doctrine, cannot be taken away by any amendments. Okay, this is part of the basic structure doctrine, which I was talking in the fundamental rights previous session, what we were doing. What is basic structure? I defined what are the things included in the basic structure. So anything disturbing that basic structure, court will review that and strike it off if it is not in lines with the constitutional law. Okay. So there are some important doctrines which are formulated based on this Article 37. Doctrine of eclipse, you may expect questions from here also. What the doctrine of eclipse, doctrine of severability, doctrine of waiver, they may ask any question. So a doctrine of eclipse is pre-constitutional law which is inconsistent with fundamental rights. They are not void ab initio from the beginning, only dormant. Their eclipse become enforceable if inconsistency is removed. I'll talk about this in the next slide. Doctrine of severability, if any part of law is unconstitutional, only that part is struck down, not the whole law. Doctrine of favor, it is not implemented in India. In the US, citizens can waive their fundamental rights. This is very important. I've included this because it is part of the syllabus. And this question is asked, doctrine of waiver, because India, it is not applicable in India. Doctrine of waiver is not applicable in India. So they may ask doctrine of waiver is applicable in US, India, whatever they may ask, they can ask that question. Okay. So fundamental rights for individuals and society cannot be surrendered. In US, you can surrender your fundamental rights. In India, you cannot surrender your fundamental rights. So we will not discuss about doctrine of waiver because this is only question. You cannot surrender your fundamental rights in India. Okay. So you cannot waive away fundamental rights in India. That is about doctrine of waiver. It is not accepted in India. Doctrine of eclipse, doctrine of severability is, we will talk about those in the next slides. So here, doctrine of eclipse, it is, there is, here they will ask case laws. Okay. Bikaji Narayan Dakras versus State of Madhya Pradesh. CP Berar Motor Vehicles 1947 gave monopoly to state in transport. Okay. So doctrine of eclipse, what it does is, so if there is any pre-constitutional law, because doctrine of eclipse, I told it is pre-constitutional law, right? So if there is any pre-constitutional law which is not in consistency with the constitution, then it will be eclipse. I mean, they will not totally abolish that law, but that law will be eclipse. It will not be functional for some time. Okay, it likes when eclipse moon or sun. Hello, please mute yourself, everyone. So during eclipse, there will be a, I mean, sun will not be visible. Let us take sun eclipse, solar eclipse. Solar eclipse, sun is not visible because moon will come between sun and earth. So once moves away, sun is visible again. Similarly, doctrine of eclipse, that particular act will be eclipsed in the sense that the act is suspended temporarily. It is not active till that act that eclipse is removed. So how that eclipse is removed? So some amendment is done in the article, that particular act, so that that eclipse is removed and the act becomes functional. So here in Bikaji Narayan Das versus State of in 1947, they gave monopoly to state in transport. Okay. After Constitution law conflicted it 19 Article 19(1)(g) right to trade. So law became dormant. 19 Article 19(1)(g) it gives right to trade. Okay. So, but this particular act gave monopoly to state for in transportation. So they Bikaji Narayan Darakdas Dakras versus State of Madhya Pradesh, he contested that now after this constitution, I am having right to say trade, so I can start a transport business. I mean, start transport, road transport. Let us say state road transport is there, right? Like APSRTC, Telangana State Transport Corporation. Similarly, the Berat Motor Vehicle Act came into existence, which gave monopoly only to the state. But 1950, when Constitution came into existence, 19(1)(g) gave right to trade. So right to trade is I can start my own transport business. I challenge this one. So that particular act, CP Berara in Motor Vehicles Act, was became dormant. And amendment was passed in 1951, again allowing state monopoly in trade. Okay. So monopoly is given again in 1951. The Eclipse law again revived and became valid. So for that 1 year period or 1.5 year period, that law was not existing. So anybody could have started transport business, I mean the road transport business, because that law was dormant and 19(1)(g) gave right to trade. So that law eclipse, if the eclipse is over, once the amendment is passed in 1951, first amendment is that law only of the constitution, which allowed state monopoly in state trade. So only state was given monopoly, private people were not given monopoly. So state is given right to monopoly in some specific trades, which is of public importance, like electricity, road transportation, railways, those things they have given. Okay. So the law was in shadows, but once the sun of amendment rose, the eclipse disappeared. That is that amendment is made in 1951. So the eclipse is disappeared and that law again became active. So eclipse is for temporaries. See, remember, doctrine of eclipse is for pre-constitution laws. They are dormant temporarily. If any amendment is passed, those will become active again. If that amendment is not passed, still they may be in dormant only. Okay. Here, doctrine of severability. So there is slight difference between doctrine of eclipse, doctrine of severability. Doctrine of eclipse, that there is a eclipse, and once the eclipse is gone, the law becomes active, and it is for pre-constitution times, doctrine of eclipse. Whereas doctrine of severability, it is for pre-constitution and post-constitution also. Okay, pre-constitution and pro-constitution also. Here what it does is, so let us take this specific case, which is post-constitution. Quixoto Holohan versus, I don't know how to pronounce, Jashiluhu. Okay, Jashiluhu. Okay, that is anti-defection law in 1992. 10th schedule was challenged. Okay, anti-defection law, the 10th schedule was challenged. Para 7 of the 10th schedule barred judicial review. So judicial review is basic structure of the constitution. But in the 10th schedule, there is a para 7 which barred judicial review in that. So it is against basic structure of the constitution. So Supreme Court held para 7 is unconstitutional. It is violating basic structure of the constitution. But same time, rest of the 10th schedule is okay. It is as per abiding every part of the constitution, but except this para 7 is against the basic structure of the constitution. So what they have done, they have removed that specific 7th para only, and all 10th schedule is retained. So removing that specific section or specific part which is unconstitutional or which is violating the basic structure, which is not in consistency with the constitution or fundamental rights, just they remove that specific part, that is called doctrine of severability. So if there is any damage, instead of killing entire person, just removing that specific limb of that person and keeping him alive, that is severability. Okay, amputing a leg or finger, whatever it is. So the bad part is removed and all other good part of that act is retained under doctrine of severability. Did you get it?
Yes, sir. Yes, sir. Like cancer, how we remove one organ and remaining in function like that.
Yes, yes. So that is doctrine of severability. Any part. So instead of removing, making the entire act as invalid, just that specific part is removed. Okay, just that here in this one, para 7 is removed because para 7 of that act, Anti-Defection Act in 10th schedule clearly mentions that there is no judicial review for anti-defection law. So that it is against the basic structure. So the para 7 is removed. Okay. So now actually fundamental rights starts from part 3, article 12 to article 35. Not all are fundamental rights. Actual fundamental rights start from article 14, that is right to equality. So it will start from right to equality only. So 12 and 13 are nothing to do with real fundamental rights, but they are definition of the state, which is the duty of the state to protect the fundamental rights. So who are state, we should know who are there to protect our fundamental rights. Okay. Then article 13 is judicial review, because anything in violation of fundamental rights, there will be judicial review and it will be against law, so it will not be enacted. That specific acts will not be it will be invalidated. So for that purposes, we have read article 12 and 13, very important for AIBE examination.
So sorry to disturb you.
You may get.
So that Muslim that act was there, no? Then what we can say that land they are grabbing it, they say it is our land. Then it is against to this fundamental right article 12, no, sir.
Which one?
That Wakfula.
Wakfla.
Oh, sir.
Yeah. So see, Wakfla is government. I will come to that. Property acts are there, separate property right. They have removed from fundamental rights actually. Right to property, article 31 was there. Okay, here itself I mentioned. Okay, so there are 6 major categories. Okay, right to equality is article 14 to 18, right to freedom article 19 to 22, right to right against exploitation article 23 and 24, right to freedom of religion article 25 and 28, cultural and educational rights article 29, 30, right to constitutional remedies article 32 to 35. Okay, but there is no article 31. So there were 7 categories when the constitution was framed. So the 7th category was removed in 44th constitutional amendment. Okay, that is right to property. Okay, originally there were 7 categories of fundamental rights. Article 31, right to property is removed. So Waqf is right to property only. That property related acts they have made separate these things. Okay, reclassified as 300A. Okay, that particular act, article 31, they have made it into article 300A. They have reclassified it under article 300 and made it as article 300A. So they removed it from fundamental rights, but there are certain rights, of course, but it is not a fundamental right. So that they can make required amendments. Government can acquire property. Government can, because there were some challenges. Right to property hindered social reforms like land redistribution, jamindari abolition. See, land was held hundreds of acres, thousands of acres in few hands only. So due to right to property, they couldn't redistribute the land, or government cannot take possession of the land for the development of the nation. So for that reason, in the interest of the country, Article 31 right to property is removed, even though it was part of basic structure in the initial. Because of the larger interest, that is allowed. Okay, there were challenges for this right to property when it is removed, but in the interest of the nation, it is allowed. So you can go to that. There are certain case laws also for this right to property related case laws. So those things you can understand very well. So again, it is reclassified as Article 308A. It is not your fundamental right. It is your limited right. Okay. So that Article 31 is removed. Now only 6 major categories are there: right to equality, right to freedom, right against exploitation, right to freedom of religion, right to educational rights, right to constitutional remedies. So we will take only first category today, right to equality. Then other things we will do in 1 or 2 more sessions. Okay, because it will be not possible to do. Fundamental rights are very important rights. We cannot complete them in the time given. It will take another 1.5 hours if we go through all those articles. So we will try to do only right to equality today. Okay. So right to equality, there are basically 5 articles under right to equality. Okay, equality before law, equality, prohibition or discrimination on the grounds of religion, race, caste, sex, or place of birth. See, this question again they will ask. Okay, Article 15 says prohibition of discrimination of grounds. So they will remove one: religion, caste, sex, place of birth. Religion, race, caste, sex. Religion, race, caste, sex, or place of birth. So out of these 4, you identify the correct. So you can straight away go to Article 15. You can check the order and you can take that one. Article 16 says equality of opportunity. Article 17 says abolition of untouchability. Just 1 minute. Sorry, some disturbances will be there. Okay. So right to equality, right to right to Article 17 says Article 16 equality of opportunity. That is another important equality of opportunity. I'll talk about the specific. The equality of opportunity is very important. Abolition of untouchability, abolition of titles. So here they ask question. Article 15 they have asked one question. Okay, Article 16, lot of questions will come. Concept-based questions also will come from Article 16, equality of opportunity. I'll talk about that equality of opportunity. That is very important. Okay, so okay, here equality before law and equal protection of laws. So the basic understanding equality before laws is everyone are equal before law. There is no discrimination. Everyone are treated equally, whether you are whatever may be your caste, whatever may be your religion, whatever you are rich, poor, higher caste, lower caste, this caste, that caste, government employee, private employee, very rich industrialist. Everyone, law is same for the country. Law is supreme. It applies to everyone equally. Okay, law protects equally. So for you, you are having more fundamental rights because you are rich. For somebody, fundamental rights are less because he's poor. No, it is protection is equal to everyone. Law is equal. There is no discrimination in the eyes of law. When you come to the court, punishment will be similar. Rich people will not get less punishment. Poor people will not get more punishment, or the rich people will go scot free. everyone will have the same CRPC. Everyone will have same IPC sections are applied, whether you are rich, poor, whatever it is. So law is supreme, law is equal, law is above individuals. Okay, that is the basic thing in the law of equality. Okay, so there is no different laws for different individuals. And Article 15 talks about prohibition of discrimination on the grounds of religion, race, caste, sex, or place of birth. Okay, the state shall not discriminate against any citizen on the grounds of religion, race, caste, sex, or place of birth. Okay, so it will not be any disadvantage if your religion is high or race, caste, sex. Let us take women, male and female have same rights. Okay, place of birth. If you are born in South India, you are born in Delhi, you are born in Ahmedabad, Mumbai, whatever place, you have the same rights. There is no discrimination. Even your place of rights, race, religion, race, caste, nothing. There is no discrimination. Okay, so you can use the public transportation in the similar way. No discrimination is there. You can use electricity. Everyone will have similar rights. So discrimination is not there and based on this religion, race, caste, sex, or place of birth. You got it?
Yes, sir.
Sir.
Yeah. So Article 16 is about equality of opportunities, matter of public employment. This is main important. So public employment, equality of opportunities is Article 16. Equality of in matters of public employment means all citizens will get employment in any office under the state. They should be given equal employment. But there are certain reservations. So that is the main challenge here, because when you are talking about equality, everyone should get equal opportunity. But no citizen, again, citizen should not, on the grounds of religion, race, should not get any benefit. This, earlier we have read it right in Article 15, discrimination on the grounds. But when it comes to job opportunities in public employment, then there is some discrimination because reservations are there. So government passed article so where they have granted reservation for some society, OBCs, scheduled caste, scheduled tribe, or backward societies. But here again, there is a new law which has come. I mean, because this is nothing in the act, it is through a case law, creamy layer concept has come. Okay, we'll not go in depth of the reservations because reservation is given in the act. So even though equality of opportunity is there, reservations is also part of that act. But there is an exception where only few people are taking advantage of the reservation. Concept is developed by Supreme Court to exclude wealthier and socially advanced among OBCs from enjoying reservation benefits. So this is wealthier and socially advanced among OBCs are enjoying reservation benefits. So they want to stop that reservation benefits for that creamy layer. Reservation is meant for truly backward, not for those who have already advanced economically and educationally. So they might have taken benefit of reservation earlier and they have taken advantage of it and they have no comfortable. So that let the benefit be given to the people, really deserving people. So that creamy layer concept is brought for that purpose, where wealthier and advanced among backward classes should be excluded from reservation benefits. Ensures equality within equality. So who are really deserving, that should be given to them, not people who are already wealthier or who have already taken advantage and have grown in their careers. And this is basically applied for OBCs only. Okay. Creamy layer stops reservation from becoming a hereditary privilege. Your father has become an IAS. Now you are an OBC. He is very well settled. You got best of the education. You are having every available things, but you want to take advantage. But creamy layer will stop because she is not hereditary. Once somebody is taken, now you are not taken. So that is the comfortable, let somebody, okay. Equality of origin is mentor. This Indra Sani case law, this is very important. These are the case laws where creamy layer is definitely specifically mentioned. Indra Sani versus Union of India. This is Mandal Commission case in 1992. They can ask Mandal Commission case or Indra Sani case or equality of law, creamy layer case, whatever they may ask. So reservations are restricted to 27% in this case. Okay. SC upheld OBC reservation but introduced the creamy layer exclusion. Equality means equal treatment within the backward classes also. Those who have reached higher status must not continue to corner benefits. Okay. Then Ashoka Kumar Thakur and Union of India. This is another important case for creamy layer. In 2008, applied creamy layer principle to education institution that was earlier only for jobs, public employment. Now it has come to education institutions also. Jarnail Singh versus Lakshmi Narayan Gupta in 2018. So here extended creamy layer principle to SC/ST promotions, not for jobs, but here it is for promotions only. Okay, creamy layer concept is given for SC/ST promotions because they have already got the job. So they are on par with other people who are in the similar job. So they can have equal benefit. They are getting the equal salary. They are having equal knowledge. So they can compete only on merit in the promotions. Okay. So creamy layer promotions, that is one which they have removed from the this thing specifically equality of opportunity. Okay. These are the exceptions. Okay. Until now, it is already 8 o'clock. So we'll take other fundamental rights in the next session. If you are having any doubts, you can ask me. You can post it in the chat. You can unmute. So we'll take that. Okay. Any questions?